All right. Good afternoon to everyone who's on the East Coast, at least. Good morning to everyone else. Thank you for joining today's Food and Consumer Product Litigation and Regulatory Update. I am Trent Taylor, and I will be your MC for today's webinar. We're very, very happy that you were able to join us today. It's been a minute since we've done one of these. We typically try to do several a year. I think the last one we did was back in the spring. Things have been very busy, which is a good thing. But we couldn't let Halloween pass without doing another one because we love doing this around Halloween and incorporating the Halloween theme. So happy Halloween to everyone. Before we get started today, one of the things I wanted to encourage everyone to do is to ask questions. If you have questions that you would like to have answered, we will try our best to answer them. Please try, there's a Q&A feature on this platform. You can use that to ask your questions or have comments. And if you think of questions later, you wake up in the middle of the night and say, aha, I wish I'd asked this question. Feel free to email us or call us or text us or however you want to communicate with us. We love talking about these things, and we're more than happy to talk with you for free about any questions you may have on any of these topics, and maybe help point you in the right direction on some of these things as well. So just keep that in mind. So we're going to launch in, and I'm going to introduce things, and then I'm going to turn it over to Katie Barber here in just a moment. Here's the contacts for today. And we provided this particular sheet just so everyone can put names with faces and has their contact information. This will be provided afterwards if you ever need to reach any of us, but you can also obviously go to McGuireWoods.com and get the same information. Here's the agenda for today. We're going to start with Katie Barber giving a U.S. Supreme Court preview. I'm going to do some food and beverage litigation issues. Allison and Royce will then handle and flag some regulatory issues for you. Jenny Price is going to handle consumer products litigation. Frank Talbot will handle sales practices litigation. And then Talene will end things by talking about Prop 65. So with that, I'm going to turn it over to Katie Barber. And we're very happy to have Katie join us. She did this last year as well. For those who do not know, she's the co-leader of our firm's Appeals and Issues Group. And she also clerked for Justice Ruth Bader Ginsburg. And we're very excited to have her talk about some cases that may impact these industries this term. So I'll turn it over to you, Katie.
Great. Thanks, Trent. Hi, everybody. Happy to be here with everyone today. And in the spirit of Halloween, we have our spooky Supreme Court picture up there, along with a much more adorable picture of my two little boys at their preschool Halloween parade last week. Got a firefighter and a Dalmatian duo. So today we're going to talk about a little quick recap of last term, and then looking ahead at kind of a continuation, I think, of some of what came out of last term. So in OT 2023, the term that ended kind of late this year, it didn't end until the beginning of June, which is unusual, beginning of July, which is unusual for the court. A lot happened, obviously, but in this space in particular, a lot happened. So the big ticket case, of course, being Loper, Bright, and Relentless combined case, where the court overturned the principle of Chevron deference, which was the idea that agency interpretations of ambiguous regulations or statutes are entitled to deference. The court held that the Administrative Procedure Act requires courts to decide legal questions in the first instance using their own judgment. It's their job to decide what the law means and whether it means what the agency says it means. So obviously that's a sea change in the way that lower courts in particular have addressed these kinds of questions of ambiguous statutes. It's not really a change for the Supreme Court because they hadn't really used Chevron in a long time, and doesn't really look like they're intending on they're obviously not intending on using it going forward. So there is still the principle of Skidmore deference is still allowed, which is this idea that an agency interpretation is entitled to kind of as much persuasive value as it warrants, which is a kind of ambiguous standard in and of itself, I think. But basically, you give an agency interpretation the weight that it is due, looking at some different factors that play into that. So that was the kind of the big line item from the last term, but you also had a couple other cases that I think reflect themes that are going to continue into this term, which is kind of the combination of restrictions of agency authority and agency power, combined with an expansion of litigants' ability to challenge agency action. So Corner Post was a case that kind of falls into that latter category, and held that an APA claim, a challenge to agency action, does not accrue until a plaintiff is injured by the final agency action. So that expands kind of the time frame and the class of litigants potentially that could sue and challenge agency action. And then the Jarchese case held that civil penalties cannot be imposed in administrative proceedings. So far, it's limited to SEC proceedings, but the decision could be read broadly and end up applying in other contexts. So that's back on the side of kind of restricting agency authority and restricting what agencies can do. And so I think those themes are kind of continuing in some of the cases that are before the court this term. Not so much in this case that we're going to start with. This first case we're going to talk about that's already been argued this term. It was one of the first days of argument that started this month. And this is kind of a nerdy civil procedure case, but one that could have serious implications for how class actions are litigated and where they are litigated. And it has kind of a fun fact pattern, especially for this group, I think. So the case is Royal Canin v. Wohlschlager. Wohlschlager, the plaintiff, and a couple other plaintiffs brought this putative class action against the sellers of quote unquote prescription dog food. So specialized dog food that you have to get a veterinarian's prescription to buy. And it's generally much more expensive than normal dog food. The plaintiffs alleged that this prescription requirement is misleading because there's not actually any medication or FDA approved medication in any of this food. And so by having to, pay these extra prices, they overpaid for this food. So they brought this putative class action in state court, in Missouri state court. And the complaint alleged only state law claims, but it did have a ton of references to federal law. It referenced the FDA a lot. It referenced the Food, Drug, and Cosmetic Act. And so there were these kind of interwoven issues of federal law that were in the initial complaint. So the defendants removed the action to federal court based on Grable jurisdiction, which is the idea that their state law claims necessarily raise disputed questions of federal law. And the Eighth Circuit upheld that removal and said that, yes, there were these federal questions implicated in the complaint. On remand to the district court, the plaintiffs then amended their complaint to eliminate the claims that that had been found to kind of be interwoven with the federal law, and they eliminated all the references to the FDA, to the FDCA, and to federal law. So they very intentionally kind of went in saying, we're going to remove what the court said were the bases for federal question jurisdiction here. And then they sought remand to state court, saying there was a lack of subject matter jurisdiction. On appeal, the Eighth Circuit said there is no federal jurisdiction here anymore. It broke away from what had been a longstanding approach by most courts to look at a post-removal complaint. If there's a post-removal amendment of a complaint, most courts would look at the original removed complaint to decide whether there was federal jurisdiction, and or would say that they were exercising supplemental jurisdiction to kind of maintain the case in federal court, even if it had been amended after removal to arguably remove federal subject matter jurisdiction. So that's what the Eighth Circuit held. So the Eighth Circuit took the opposite tack and said, no, you have to look at the existing amended complaint, and there's no supplemental jurisdiction that can be exercised here, and so you have to remand to state court. So this is up at the Supreme Court now. There has already been oral argument on this, and it's interestingly, I think for all that the Eighth Circuit was kind of an outlier in reaching this decision, the argument, I think, did reflect that perhaps that as a textual matter, there might be some justices who think that that was a correct approach. The argument really centered on kind of the text of 28 U.S.C. 1367, which is the supplemental jurisdiction statute, and just how to read that language and what it means. That was really kind of the center of the debate. And on the other hand, you had some justices who are kind of the more textualist, really saying, well, there really doesn't seem to be, a basis here for keeping post-removal amended complaints. If we think there's no subject matter jurisdiction, that generally means we have to kick it out of federal court. Versus you had, especially Justice Kagan, some other justices pushing back saying, well, this is kind of an aberrational rule, but it's not, it doesn't come up that often. It's a discretionary rule that basically allows a federal district court to keep a case, but it doesn't require it to. This is going to have a limited impact if you keep this rule, and kind of more of like a practical argument. So it'll be interesting to see how it shakes out. It does, if the Eighth Circuit is upheld, that has potentially a large impact on class action litigation, where frequently defendants are trying to remove to be in federal court. They prefer to be in federal court, and the plaintiffs are trying to avoid that. This kind of gives the plaintiffs more tools in their toolkit to try and do that and try to keep cases in state court where they first filed. Okay, moving on to another interesting kind of question of potential liability of defendants, and how they can get sued. So this is the medical marijuana versus Horn case. This case arose out of a truck driver who he had some injuries from a long ago car accident. He was kind of struggling with some just aches and pains and trying to find relief for them. And so he found this product called Dixie X that was advertised to contain only CBD. And he took some extreme measures, really, or some very thorough measures, at least, to verify that it only contained CBD and not THC, because as a commercial truck driver, he knew he was subject to routine drug tests, and that he could not ingest THC if he wanted to pass those drug tests. So he did all this kind of background work, looking at the advertising. I think he called the company. He did all these things to try and verify that there was not going to be THC in the supplement. And it was marketed as containing only CBD. Then he took it. Then he failed multiple drug tests, and his employer fired him. So he brought a civil RICO action against the makers of Dixie X, alleging that they had engaged in mail and wire fraud that had caused him to suffer injury to his business or property. And that's the standard for bringing a civil RICO action. The Second Circuit held that, against a challenge by the defendant saying, well, him losing his job, or he didn't actually suffer a qualifying injury to business or property. Really, the injury here was just that he ingested a substance that he didn't intend to ingest. He was misled into doing that. And then he, kind of the steps that flowed from that were, then he failed the drug test, then he was fired by his employer. But those injuries were kind of kind of flowed from. They were not kind of the proximate first injury that was actually caused by what the Dixie X makers did. And so the Second Circuit disagreed, though. The Second Circuit said that losing his job did qualify as an injury, a business injury, because your employment is business. And even though there was this like antecedent personal injury that had to happen before you got to the point of the business injury, it didn't matter, that he still had the qualifying injury here. This case has already been argued at the court as well. And it's, again, another case where you have kind of competing textual readings, and the one reading, especially the plaintiffs, could really be a pretty expansive one that could have major implications for how plaintiffs are able to try and seek their entities, seek to hold people liable for things. Civil RICO is something that's been, long used creatively, but, it's understood to not apply to personal injury. But if there is this kind of broader definition of what qualifies as an injury to business or property, there are potentially a lot more lawsuits that could be brought under civil RICO, which also does include a treble damages cause. So obviously an appealing avenue to litigants. And so I think likely, though, based on the argument that how it went in argument, there does not seem to be an appetite by the majority of the court to uphold the Second Circuit's reading. I think, although RICO is meant to be read expansively, there is concern that this would be reading it too expansively. This really isn't what it was intended to get at, and this would be kind of a broad over-reading of it. So we will see what happens there. Moving more to like the agency action piece of things, continuing on from last term, the last two cases we're going to talk about are both cases involving the FDA, both cases involving the FDA's conduct under the Family Smoking Prevention and Tobacco Control Act, which is a 2009 statute. And that statute was passed largely with the intent of kind of tamping down on preventing, addressing the fact that there are many young people smoking. And what the statute does is it requires a person who is going to introduce a new tobacco product to the market to obtain authorization from the FDA before doing so. They have to make what's called a pre-market tobacco application, and then the FDA can only grant the authorization if the applicant shows, among other things, that marketing of the product would be appropriate for the protection of the public health. And what that standard means is basically, on the one hand, is it going to kind of be something that helps existing smokers, existing users, by giving them a product that's maybe less harmful than existing products, giving them kind of another option. So, instead of cigarettes, here we have vapes. But balancing that potential benefit to existing smokers against the risk that this new product might incentivize new users, people who are not currently using tobacco products, and really, namely young people, is it going to cause them to start using tobacco products? And so the applicant really has to kind of show that the balance weighs in its favor of it's going to be more beneficial to existing users than it is going to be harmful or create new use. They initially were kind of not covered by the statute, and then they became covered. And so then you now had thousands of authorizations from the FDA, and the FDA denied all of them, basically saying that they were too attractive to young people, and whatever benefit there might be to existing smokers, there was not evidence. There wasn't really evidence that there would be a benefit to existing smokers, versus there were also these known risks to young people, and so it was not going to be appropriate for the protection of the public health. Didn't meet the standard. So a lot of courts of appeals heard appeals from these heard challenges to these denials. At least 7 courts of appeals all upheld the FDA's action and said it was not arbitrary and capricious. The Fifth Circuit took a different tack, as it kind of tends to do these days. So the Fifth Circuit broke away from these other 7 courts of appeals and said, no, this was arbitrary and capricious. The decision below is pretty entertaining to read. They basically say the FDA sent these applicants on a wild goose chase, but there wasn't even a goose. And they basically kind of did this runaround on them and said, if you do X, Y, Z, then you'll probably get approved. And then actually said, no, we're not even going to look at X, Y, Z, and we're not going to approve anything. So this is a routine kind of arbitrary and capricious challenge to agency rules in this kind of newer market. But you do have something that's been a recurring theme in a lot of recent Supreme Court terms. You have something where the Fifth Circuit is kind of going out on its own path, separate from other courts, and not clear that that's always. Sometimes that's gained some traction at the courts. Sometimes they're just too far out there, and the courts kind of bringing them back in line. So this one has not been argued yet. Argument has not been scheduled, so it'll probably be argued kind of later on in the term. It has an interesting relationship, I think, to then the next case and final case I'm going to talk about, which arises out of basically the same circumstances, these denials of marketing authorizations, but it has a different issue. The issue here is, where can people who are denied those authorizations challenge that denial? So the statute at issue says that any person adversely affected by a denial may file a petition for judicial review either in the District of Columbia Court of Appeals or in the circuit where they reside or have their principal place of business. So this venue provision that is meant to kind of restrict where people can bring these challenges to the FDA's action. And so this case, again, arose out of these denials of market authorizations for flavored vape products. The manufacturer here could only have sought review under the strictest reading of the venue provision in the Fourth Circuit, because that's where they reside or have their principal place of business, or in the DC Circuit. But what they did instead was when they filed their petitions, they had the petitions joined by retailers of these vape products who were located in the Fifth Circuit. And they said, if we have these retailers joining our petitions, then that satisfies the venue provision, because there is someone who is a petitioner here who resides and has their principal place of business in this circuit. That has not traditionally been how the venue provision has been interpreted. And interpreting it that way would really broaden people's ability to bring these challenges and really to forum shop and to select the Court of Appeals where they think they would have the most favorable precedent. And so it's no coincidence that I think the Fifth Circuit is, again, the court here, the Fifth Circuit being the only one that came out in favor of the petitioners in the Wage and White Lions case. And then here it's also saying, yes, it is enough that just any petitioner has their principal place of business in this circuit. Again, a pretty broad reading of the venue provision that would kind of blow it open, really. So I think, and textually, I'm not sure it's all that supported, but this petition was just granted, the cert petition, by the court very recently, so that it also will be argued, I think, later in the term. But again, here you see this kind of intersection of just how broadly how broadly are people able to kind of bring these challenges to agency action, and especially if you're able to kind of sue wherever you want and you can pick the forum you like. Say it's the Fifth Circuit that's going to have favorable precedent and you think they're going to come out your way, then that kind of how these things are all kind of working together at once. So it'll be an interesting term, and for many reasons, I'm sure there will be lots of other interesting cases besides these ones, but it'll be fun to watch what happens. And I'll turn it back to Trent with that.
Yeah, thank you so much, Katie. Really appreciate it. And you know, fascinating sort of regulatory enforcement type issues, at least at the federal level, and it'll be great to watch those going forward. So I'm going to talk about food and beverage litigation now. I wanted to start with, we're doing slides of kids. I have my kids, although this is dated, they're no longer trick-or-treating, so I'm very sad about that. But this is back when they were, and I particularly love the hot dog outfit that my youngest wore, in part because he is a hot dog. And I also have my favorite candy, at least right now, Reese's Fast Break, which is delicious. And, you know, trying to lean into the Halloween theme. But let's get into the content. And first of all, what I'm going to do is I'm going to talk about some of the new cases that we've seen in the recent weeks and months that I think are worth being aware of. And the first one are some new greenwashing claims. Now, the whole concept of greenwashing, environmental claims, obviously not new. This is something that we have been warning about for years, I think. And we have seen, you know, plenty of other suits, and they continue, I guess, is really the point. And I think we saw them a lot more in consumer products like non-food and beverage, but we're starting to see them more with food claims as well. And so I think just want to flag that the first one of these cases focuses on sustainable, a claim of sustainable related to cocoa. And it's saying that that's misleading because of its supply chain contributing to, you know, unsustainable, grievous labor abuses, child labor being probably the most important and prominent of those, at least, allegations. And I'm going to come back to that particular claim because we have another case that I'm going to talk about here in a few moments where we actually have a result. But those types of cases continue to be filed. The second one is actually by a nonprofit that was in DC Superior Court. That's something we've talked about before. We see those, and it is going after net zero and climate smart. So the bottom line here is, with these types of claims, just be aware if you're putting environmental claims such as sustainable or anything along those lines, you're going to want to really think through what the risk level is and whether you're opening yourself up to a potential class action or an action by a nonprofit in DC Superior Court or something like that, because these continue to be filed. So that's really flagging that particular issue. The next one I want to talk about are a series of cases that I at least put under lab testing. And there, as you all know, I mean, Plaintiffs' Counsel will go out and they will grab products and they will send them to labs. Some of those labs are maybe legitimate labs. Some of them are not. And they will test for various things to see what's in them. And then they will attempt to sue over that. That's not a new concept either, but I at least believe that I'm seeing more of those recently than I have seen in the past. There are a few examples on this particular slide. The first one relates to Cocoa Puff cereal and a claim that it contains undisclosed and high levels of lead. And you can see I actually put the levels here just below the maximum allowable daily level of lead per day. And the allegation is that a lot of people eat more than 1 cup serving of Cocoa Puffs. Because how could you not? I mean, Cocoa Puffs is so good that you're obviously going to want to have a little bit more than you normally would have. But that's the allegation, and that there are high levels of lead, and that it's not listed in the ingredients, and that it's deceptive. The second one has to do with gluten. And as you can see, this is Trader Joe's. They have a gluten-free bagel. And the allegation is it actually contains high levels of gluten that exceed the legal limits for the claim. So obviously this was something that also lended itself to laboratory testing and was recently filed. And then the last two have to do with PFAS. And that is a huge problem right now. And we're going to talk about PFAS and products throughout my presentation. And I believe Jenny is also going to talk about PFAS. And if you hear nothing else today, just be aware PFAS, I know it's not a new thing, but the litigation is really starting to rise in that area. And we're seeing it in every aspect of consumer class action litigation right now, whether it's food and beverage or consumer products. And, you know, just be aware that it's huge right now, and that there are a lot of lawsuits being filed. The two that are on here, one is about Simply Orange juice products containing significant levels of PFAS. And then there are 2 recent settlements here that are listed, one about PFAS in kombucha, and the second about PFAS in Kerrygold butter. And then one other one that I wanted to note, which is very recent. This was from late last week, that was filed against Hershey's and their Bubble Yum bubble gum. And the allegation is that its gum contains PFAS, and, you know, and that is wrapper in gum. So it's not just the gum itself, but the wrapper as well. And there's going to continue to be a ton of these type of suits. You can see here in this description, one of the things that's always sort of a challenge for plaintiffs' counsel is to figure out, well, you know, the fact that it contains PFAS in and of itself does not necessarily mean that they're going to have a deceptive trade practice act claim. They need to find a hook for it. And you'll see in the last slide, in the next to last bullet point about Lorenz v. Coca-Cola, there in that PFAS case, that the plaintiff's counsel targeted the claim of pure filtered water. So they're able to say, well, you said pure filtered water, but it contains PFAS. So that's the hook there. In the Bubble Yum one here, they actually had to go to their website. And their website has what lots of corporations and food manufacturers and consumer product manufacturers have, where they talk about being transparent about the ingredients in the products, to meeting the highest quality, safety, and sustainability standards. And that is the hook there that plaintiff's counsel is using to try to say that it's deceptive that Bubble Yum contains PFAS. So I guess here's the takeaway on this. If you don't have your arms around PFAS in your product, your packaging, or in your supply chain, if you don't have that all buttoned up, then you're going to want to make sure that you're paying close attention, because there's going to be a lot more litigation surrounding this. We think it's only going to increase over time. And then one more word about lab testing. Some of these lab cases that are based on lab testing are bespoke lab testing, where, as I mentioned, the plaintiff's counsel will go, they'll grab the product, they will send it to a lab they know and trust. Sometimes that's, as I said, a reputable lab, sometimes it's not. But sometimes they also, and this is sort of the lazy way to do it, I guess, not to be pejorative about it, but there are plenty of universities and nonprofits that release their own studies. One of the things that you'll see here in a couple of minutes is there was one that I think it was UCal Davis released a study on the purity of avocado oils. And they had a bunch of oils, and then they said, well, here are the ones that have other things in them. Well, not surprisingly, plaintiffs' counsel saw that and went and filed lawsuits against a few of those manufacturers. And so that's something else we see. So obviously, if you see studies out there that, whether it's from a nonprofit or from a university, about, we did lab testing of this particular product, or a lot of different products in an industry, just recognize, certainly if you're on that list, you may see a lawsuit next. And even if you're not on that list, it may sharpen the focus of plaintiffs' counsel on that particular industry. So keep that in mind. Okay, some other new cases, naturally flavored and free of artificial flavors. That's not a new concept. We literally have talked about that on every single one of these. And I guess the real takeaway is that they continue to be filed. It continues to be an issue. And it always sort of surprises me that every single time we do this, when we look at sort of the number of cases that are being filed, a lot of them continue to be related to naturally flavored, free of artificial flavors, that kind of thing. So here are a few examples here. The first two relate to cereal bars containing malic acid. Now, once again, malic acid, it brings that tartness to a lot of different types of products. It's in a lot of different types of products, and that has been a focus recently, and even before. I mean, this has been going on for a while, and I think malic acid cases had sort of a higher rate of getting past motion to dismisses than we've seen some other these types of cases. And so it continues to be a theory and a claim and an ingredient that plaintiffs' counsel like to focus on. And so the takeaway here, and of course the last one here, is it's not cereal bars, but sour gummy vitamins. The takeaway here is that if you have a malic acid or have a natural flavors or free of artificial flavors claim on your product, then you're just going to want to make sure that you have fully scrutinized that and done a risk assessment to ensure that you have reduced the risk as much as possible. So if that's something we can help with, please let us know. Pure. So this is the one I just referred to a couple of minutes ago about avocado oil. Two recent suits, one against Target, one against Walmart, claiming that their avocado oil is impure and not 100% pure. And this was based on a study by a university. And we continue to see pure suits as well, where there's a particular claim that says this particular product is 100% pure, or it doesn't do that. It's mainly this or mainly that. You'll see a 100% raw honey lawsuit that we'll talk about here briefly in a couple minutes. But those continue to be popular. So you're going to want to make sure that you are aware that those continue to be filed, and it may mean that these continue to be targets going forward. All right. Health Halo. Once again, Health Halo are lawsuits targeting healthy claims or healthy type claims, continue to be hot. These are not new either. There's been a ton of these. And they have had a greater degree of success than other claims for plaintiffs' counsel. And because of that, we continue to see it. So this is just one example of a recent lawsuit that was filed against the manufacturer of Poppy. And basically the claim was that these Poppy prebiotic sodas, there's claims about that it's prebiotics for a healthy gut. There's a lot of other claims that were targeted, including in some of their marketing. And the allegation is, well, they're actually full of sugar. And because they're full of sugar, it's really not healthy at all. And this Health Halo presented with, what is pretty nice, colorful marketing of fruits and that kind of thing, means that consumers are being deceived. That's the lawsuit. And so we continue to see a lot of those types of claims. If you have a healthy claim or what might be characterized as a health halo, once again, it's worth getting a risk assessment or performing a risk assessment if you have not already done so. All right, what I want to do now is talk about some recent decisions. I mean, it's great to talk about new lawsuits to know what's being filed, but it's also, I think, important to see what courts are ruling. What are getting past the motion to dismiss stage? Which classes, if any, are getting certified? Now, I'm using this particular Jeff here. It's from, you may recall, this is one of the scariest monsters that I can recall. I'm a bit of a movie buff. This is from Pan's Labyrinth. So hopefully I'm not creating nightmares for anyone out there. But there are some scary decisions out there that have transpired in the last 2 or 3 months that I wanted to share with you. The first one, or the first two on here, are actually class certifications that were granted by courts. One in the Southern District of California, one in the Northern District of California. The first one relates to sustainable. And this is what we were talking about earlier. There's a new one of these lawsuits. The new lawsuit was actually filed before this class cert decision. I suspect we're going to see more of these, given that there was success in getting a class certified in the top one here. I wanted to briefly mention what the claims at issue were in this Falcone case. So you obviously see sustainably sourced is one of them, but it's also responsibly sourced, improves the lives of cocoa farmers, and it includes logos for Nestle Cocoa Plan, Rainforest Alliance, and in some cases, a UTZ sustainability certification program. And so the allegation there was that there were a lot of the sustainability representations on their packaging, on their websites, and that it wasn't actually true. 9 different products were certified as part of this, and what you typically see, I think the original attempt by plaintiff's counsel was to focus on 59 products, but the court, I think, limited it to 9. The court rejected arguments from the defendant here that there were different variations of messaging and claims on the packaging, and also rejected a claim that there was a different understanding of what sustainable and some of these other claims mean. So they also, the defendant argued that these representations were not material, and they used an eye tracking study and expert testimony to show that most consumers were not exposed to these label statements, but the judge rejected those arguments as going to the merits rather than class cert. So that obviously is not one that is good for defendants, and it's something that we'll want to continue to watch whether this leads to a lot more of these lawsuits, and I think it will. The second one has to do with protein. And as y'all know, we've talked about protein quite a bit, and there's been a number of suits, including by one of my former classmates with Gutride Safier, and he got a case, class certification granted in this particular case involving Dave's Killer Bread. And I think that's significant just because there have been a lot of cases involving protein, and it could lead to more. So that is something else, I think, to watch out for, more protein content claims. And then we have 2 motions to dismiss that were denied. The first one relates to defendant's dark chocolates containing dangerous levels of lead and cadmium. One of the arguments that the defendant in that suit made was that heavy metals are found everywhere in the food supply, so finding trace amounts in its chocolate bars is unavoidable, but the court found that argument unpersuasive and said that plaintiffs, at least at that particular juncture in the suit, have adequately pleaded that they were not adequately warned about it. And then the last one here relates, and this one is, I think, pretty interesting, and it relates to Health Halo, which we've already been talking about. And essentially, the claim here was that there was I believe it was a Gatorade protein bar, which, I mean, it looked like it, but I sometimes run races and whatnot, and there's a lot of protein bars and sports foods out there, and the allegation is, well, this is being marketed as a protein performance item, but it really isn't, because it contains so much sugar. It shouldn't have been a protein bar. It should have been a candy bar. And so that's the basic allegation here, because I think they said that it has 20 grams of protein, but has 29 grams of sugar. So 30% more sugar by weight than it has protein. So that's the claim. Health Halo. We're going to continue to see those suits. So that's just a heads up. And then one more recent decision of note, at least with regard to the scary, is related to a Second Circuit reversal of a trial court dismissal of a claim related to organic whole wheat flour. This is, the type of thing. There's been a lot of case law on, front label, back label, that kind of thing. One of the things I just wanted to point out about this particular suit is the Second Circuit has, at least from my perspective, has been pretty hostile to defendants in consumer class actions in recent years. And this is just another example of that. So something to be aware of. And then finally, before I turn things over to Allison here in just a moment, I wanted to briefly mention some recent decisions of note, the not so scary, the good, the types of decisions that we like to see. And the first one is just affirming the dismissal of a class action related to 100% raw Tennessee honey, which is always good to see an affirmance of a dismissal. The second one is a dismissal of one of these claims involving malic acid. That is also good to see, because as I mentioned before, a lot of those have disproportionately gotten past the motion to dismiss stage. So that's a welcome decision as well. On the Castillo case, that's the one involving Prime Hydration, alleging that defendant's product deceptively marketed its product as healthy when it contained PFAS. So this sort of combines the health halo with PFAS, and once again, hitting hard on the fact that PFAS is the big driver in this space right now. And there, I say that's not so scary or good, and it is, but it was granted with leave to amend. So we will likely see this coming back. The court found that some of the statements that were targeted, such as refresh, replenish, and refuel, were general vague statements, essentially puffery, but they're going to give plaintiff's counsel another chance. And then the last thing I wanted to hit real quick is this Sorkin v. Kroger case, farm fresh eggs. The court granted the motion to dismiss there, and the court said, at bottom, Sorkin has not plausibly shown that his definition of farm fresh aligns with the expectations of a reasonable consumer. Words don't mean whatever we want them to mean. A plaintiff cannot sue based on every fanciful idea that springs to mind after reading the label. Simply put, there is nothing deceptive about farm fresh eggs. It is about origin and timing, nothing more. And the term farm fresh means precisely what it says. The eggs are fresh from a farm. So the allegation there was that they were not free ranging, and instead they were caged hens, and the court rejected it. So that's welcome language and a welcome result there. And then the last one here is granting a motion to dismiss in a case involving microplastics, which is another big target right now. And that's something that Jenny, I know, is going to talk about, so I will leave that for her. And then finally, my takeaways which I've already mentioned and I will not spend time on here, but if you get the slides later, you can have this for you. But here are some of the things to watch out for. So my time is up. I am now going to pass the baton to Allison.
Thank you, Trent. And if Trent's nightmare fuel slides from Pan's Labyrinth did not give you nightmares, this slide surely will. Wanted to just flag my favorite Halloween candy. It's an old school throwback, and you can never make me like something better. It is 100 grand. I think I even claimed that last year. Love me 100 grand bar. There's nothing quite like that chew. So I'm going to dive into some quick regulatory developments, primarily on the state level. One quick FDA update to share. So California, we've been talking a lot about California the last year or two. California Food Safety Act was passed last year. A few states we're going to talk about have tried to follow on that trend, banning BVO, potassium bromate, purple paraben, and red number 3. California then followed up with their School Food Safety Act, which now prohibits school districts, county superintendent of schools, or charter schools, if you have grades from K through 12 or any combination thereof, 1 grade, all the grades, they cannot offer foods or beverages that contain blue 1 and 2, green 3, red 40 now, we're moving away from red 3, yellow 5, and yellow 6. So the argument here is that you get a lot of free lunch program in schools, and the school system should not be selling products that contain these dyes. Now, this includes prepackaged foods. So this is including things like granola bars and Gatorade and sports drinks, things like that that may contain these ingredients. So the school districts cannot even offer these at this point. Titanium dioxide had been introduced in this bill, but was ultimately stripped. So everybody keeps trying to go after titanium dioxide, and it has lived to fight yet another day, at least in California. So the products containing these ingredients cannot be sold on school grounds from midnight of the school day to 30 minutes after. So this, potentially puts a dent in some of those after school activities. I know when I was in high school as a kid, we used to, as soon as school was over, Key Club was selling sodas and candy bars. That's, if we're within that after 30 minutes after the end of the school day, selling these products is still not permissible. There is an exception for fundraisers. So if you want to do fundraising, sell the $1 candy bar. I'm not sure if they're still $1. I think I'm showing my age. Where kids can sell the cookies, cookie dough, candy bars, things like that. It has to be off school grounds, or it can happen as long as we're at like the 31-minute mark after school ends. So this will be effective December 31st, 2027. So this gives the school systems a little bit of time to work with their suppliers and work on their purchasing, work on their menus to ensure that they're not offering foods that contain these dyes. So, California has been a bellwether. We expect to see some additional states maybe try to follow on with similar bans. FDA's response when this was passed was effectively repeating what they have previously said, which is, look, we've reviewed and we will continue to review food dyes and their effects on children's behavior. We have done studies, others have done studies that have shown that, the scientific evidence indicates most children have no reaction to foods containing color, but there may be some children with sensitivities. So FDA continues to sort of stand behind the previous research and say, for the time being, we think we're good here. That said, and I know we've talked about this in previous webinars, so I don't want to harp too much on it, there is still a petition for FDA to reconsider FD&C red number 3 and remove it from the approved list. That has been out there for quite some time. Comments were closed. 34,000 plus comments were received. FDA has still not taken action. There's no real set requirement for when they have to respond to the petition. So it is typically within a couple of years. So we're still watching this and waiting to see what FDA is gonna move on. So we've also got, on the heels of the California food safety ban, not the school food safety, but the general food safety banning BVO, banning potassium bromate, polypropylene. Sorry, that's not right. Polyparaben, sorry. We have 11 states total now who have introduced some form of legislation. Most of them mirror the California bill. Some states include titanium dioxide, some do not. So most of these states, as we'll see, legislation has stalled in many of these states, some of them in states where we don't have a year-round legislature. So some of these, the 4 that are on this slide, which are now in our graveyard, we've been tracking for over a year. So we wanted to flag these, that we're still keeping an eye on these because we think these may eventually have some level of success. So New York's Senate Bill 6055, that one has passed away when the session ended. This one included the titanium dioxide ban in addition to the others. And this year was amended to add the word that I absolutely cannot pronounce, though I've tried many, many times, but it's the dough conditioner that everybody calls yoga mat. So you remember a few years ago, there was a sandwich chain where some lab had done a study and said, hey, there's an ingredient in their bread, which is also an ingredient that is used in yoga mat. We will provide you the slides and you will see how to pronounce this yourself, but I will give it a shot as azodicarbonamide. Not a scientist, sorry for butchering that word. So that got added to New York's bill this year. Interested to see if they reintroduce the legislation, they include the yoga mat dough conditioner ban. And so we're going to be tracking that one closely. So Illinois Food Safety Act also passed away, would have been effective in 2027, almost verbatim, the California Act. And then Missouri's House Bill 2474 was introduced, never got any traction. Again, virtually the same as the CFSA, the IFSA. And Washington's House Bill 1921 had very similar requirements, same effective date, was introduced and never got past that point. So kind of dead on arrival. So we're going to continue to track these in the other 6 states who have legislation pending here, but we think this is sort of the beginning of a trend. We expect to see a few more states add on this year and next year and sort of try to almost force FDA's hand a little bit on some of these ingredients. So in light of California Food Safety Act, earlier this year, FDA did go ahead and ban BVO. They had been reconsidering the status of brominated vegetable oil as an approved ingredient, did some additional investigation, and July 3rd, they officially announced the revocation. The rule was effective as of August 2nd, 2024. So BVO is no longer allowed to be in food or beverage products for human consumption. It's not going to go into effect until 2025. So we've got a little less than a year, August 2nd, 2025, to give the manufacturers an opportunity to reformulate, to work with their suppliers to sort of go through the current supply that may contain BVO. But this is one that if you have BVO in your products, you should absolutely be taking steps at this point to remove those from your products. So I'm going to pause here for a second and share my screen because we did have some additional regulatory info that we wanted to share. So California, here we are again. Thanks, California. They have now banned the use of the phrase sell by on food and beverage packaging. So as of July 1st, 2026, food manufacturers, processors, and retailers who label products fit for human consumption, where such a label is required, or if you're going to voluntarily continue to label your products as best by, you can only use the terms listed here. Best if used by, or best if used or frozen by. And those are the ones that are talking about your quality. The food is tastiest by. Still safe to eat, but maybe not as fresh and as flavorful. A lot of your canned goods, a lot of your boxed goods, things like your cake mixes, where your moms and your grandmas may have a box of Swansdown cake flour in the back of their pantry that says, best by 2022. It's not going to kill you to eat it past that date, but it's more of a quality date. But for your food safety, you must use the terms use by or use or freeze by to indicate the food safety. These are the actual expiration dates. Food is no longer safe to eat past this date. If your packaging is small, if your labels are tiny, Best By or BB and UB can be used instead of Best By or Used By to indicate the Best By and Used By if it's too small. But you can no longer use the phrase sell by. You can continue to use it in your internal stock rotation codes. So you can have in your codes that your stores, your retailers are going to use to indicate, hey, we should push this to the front rather than the back. We need to get this off the shelf sooner rather than later. That can continue to be used, but it should not be easily legible by the consumer. So your consumer should not be able to sort of discern what this sell by date is and interpret that as a replacement for the best if used by or the used by date. Grocery stores can continue to use the phrase packed on for their prepared foods. So your rotisserie chickens, your in-house made prepared meals, prepared dinners, things that you can pick up in the deli or the meat counter, they can continue to use the packaged on date. And the best if used by, the best by, the sell by, the used by dates do not apply to wine, distilled spirits, infant formula, eggs, beer, or malt beverages. So not a violation to continue to list your vintage on your wine, and does not apply to infant formula, eggs, beers, or malt beverages. So I'm going to stop sharing my screen and jump back to my final slide. So just to give you one more scare, we do have a few more recalls that are out there currently. The top little squiggly monster there is Listeria. The bottom squiggly monster there is Salmonella. So now you know exactly what we're talking about every time we have a recall. We've had a significant amount of recalls for Listeria and Salmonella this year, particularly in the last 6 months. One of the most recent one, which I'm sure most of you may have been affected by, was the Bruce Pack recall. At last count on Sunday, it was 11.8 million pounds. That number may still have gone up because they're still identifying products. Part of the problem was the prepared chickens and the prepared ham had been included in small prepared salads. So, and basically every grocery store was using the same producer for preparing those salads. So Trader Joe's salads, Aldi salads, Lidl salads, those little $3 salads that you buy, all of those were affected. Home meal kits, things like Home Chef and Green Chef were also, I'm not sure if those specifically, but those home meal kit companies were also affected. So significant recall, and it's still ongoing. They're still investigating. Frozen toasted waffles, Sladley, got added to the keep out of your trick-or-treat bag. Again, similar thing, manufacturer. There were greater than 200 labels of waffles sold in the US and Canada, contaminated with Listeria. Alfalfa sprouts, green onions, also recalled for Listeria and Salmonella respectively. And then Palmer Candy Company, to end on a sad note, for Halloween. There were various snacks that were recalled for potential Listeria contamination. So definitely check your candy, check your trick-or-treat bags this year, and I will go ahead and pass it over to Royce.
Hey folks, hope everyone is doing well. Man, that is a much nicer photo of me. Anyway, so I just want to add some light humor here. I really thought about this, and there are some really good spooky films out there on food and drug issues. There's Children of the Corn, Soylent Green, Island of Dr. Moreau, Sweeney Todd, the Demon Barber of Fleet Street, definitely not CGMP. The Platform, that one's freaky. It's on Netflix. It's about these people that eat food that falls down. And then my absolute favorite, the dinner scene from Texas Chainsaw Massacre. It got me into food and drug law. Anyway, that's my son dressed as a fox, Chicago in the background. Just wanted to show that don't practice food and drug law all the time. I actually raise humans. So we've seen a lot going on with him, and we will continue to see a lot going on with him. And just as a refresher for folks on the call, federal government and a lot of states make the distinction between hemp and marijuana. Marijuana is anything above 0.3% Delta 9 THC on a dry net basis. Don't ask the federal government how they measure that 0.3%. And it includes all the constituents and components of the hemp plant, which when Congress made the 2018 Farm Bill, didn't really dabble in Delta 8, Delta 10, and all the other active psychogenic ingredients, and inadvertently legalized to some extent Delta 8 and Delta 10. So where are we now? You know, we know that FDA is not really inclined to enforce Delta 8 and Delta 10 products, even though it has said numerous times that their inclusion in food is automatic adulteration. We also know that DEA is not necessarily running to enforce Delta 8 and Delta 10 products because they believe that the federal government has tied their hands in terms of whether or not Delta 8 and Delta 10 can be on the Controlled Substances Act. We see continued stagnation in Congress. We've got a new administration either way coming up on Tuesday. And we have just, this is not where I thought we would be, you know, almost, you know, 7 years into the world of hemp, where we just don't have any certainty at the federal government. So because of that, the states have stepped in aggressively. It is an absolute 50-state quilt on whether or not Delta 8 and Delta 10 is lawful. Why do I bring this up? Because Delta 8 and Delta 10 are hot items. They sell off the shelf. They're in C-stores. They're in, you know, stores, head shops all over the country. Lot of money to be made there. And we have an absolute patchwork quilt of some states like Missouri and California, which wanted to ban these products in food, only to encounter litigation and lawsuits. The California one is evolving. We have Florida, where the governor stepped in and vetoed the law that banned Delta 8. And then we have, for example, in Virginia, where the state of Virginia has a fully, you know, as operational as it can be, program to lawfully sell certain Delta 8 food beverages. So if someone comes to you and says, I got Delta 8 and Delta 10 for sale, or Delta 9 from hemp, carefully evaluate the risk where you're selling it in the state. And we're really good at that here at McGuire Woods. Moving on. So FDA's scary sodium scare. This one, I like this meme. I made this meme myself, but it's like aliens are coming for all the great snackies we have in the world, because there's lots of sodium. Sodium is flavor, and